Smokers. I'm going to going for tonight. My name is Ann Craver. Nancy, unfortunately, could not be here tonight. She's at a meeting in Seattle, Washington this evening, so she's sorry to miss it. But we've got three terrific speakers tonight. Very exciting on voting rights. So without further ado, I'm going to get going with the program. Our first speaker tonight is attorney Denise Lieberman. She's a nationally recognized expert on voting rights, and she's a senior attorney with the Advancement Project, a racial justice organization based in Washington, D.C., that works to eliminate barriers to full participation in democracy. A seasoned constitutional and civil rights attorney for over 20 years, Lieberman has been at the forefront of voting rights debates in the home state of Missouri and across the country. As senior attorney in Advancement Project's Voter Protection Program and Right to Vote initiative, Denise brings her expertise to voting rights strategies on the ground in Missouri, coordinating the Missouri Voter Protection Coalition's efforts to oppose restricted voter ID proposals in the state. She has litigated challenges to discriminatory photo ID provisions in Missouri, Pennsylvania, Wisconsin, and North Carolina, and has prepared testimony on voting rights for the U.S. Senate Judiciary Committee to legislatures in several states, and has been featured as a voting expert on MSNBC, CNN, PBS, New York Times, Washington Post, USA Today, and other weekend outlets, just to name a few. Denise is also an adjunct professor of law and political science at Washington University in St. Louis, where she teaches courses on constitutional law, civil rights, and voting rights, and she's presently teaching a course at Washington University this semester on voting rights. She also was recently featured in an article in the November issue of the American Bar Association Journal entitled "Appellate Courts Are Dismantling Stricter Voter ID Laws." So she's our first speaker, and she's the winner, the recipient of many, many awards. So we're very pleased to have her as our first speaker tonight. Our second speaker is Steve Davis, an attorney who practices complex litigation at the Washington, D.C.-based law firm of Aaron Fox, where his practice focuses on Fifth Amendment property rights cases and election law. Steve previously served as the chief clerk and administrator of the Missouri House of Representatives, as an assistant U.S. attorney, and as the Missouri Election Day operations director for the 2012 Romney presidential campaign. Steve is an adjunct law professor at St. Louis University, teaching election law. And last but not least, because he's a fantastic speaker too, is our Representative Michael Colona, a Democrat who represents part of St. Louis City, District 80, in the Missouri House of Representatives. In addition to his legislative duties, Representative Colona is an attorney and has served as an adjunct professor of criminal justice for the University of Missouri St. Louis. He is a board member for the St. Louis Effort for AIDS, an ex officio board member for the Grand Oak Hills Neighborhood Association, and a member of the Missouri Association of Trial Attorneys. He has also served as president of Truman State University Alumni Association. So let's welcome our three. So Denise is going to start and give us a background, a little bit of history, and then we'll go forward from there with our other two speakers.
All right, good evening. Thanks so much. I'm really excited to be here and excited to be speaking with Stephen Davis. Again, we've done programs for the Bar Association together in the past, and even though we frequently have been on opposite sides of some very similar issues, I think we both really enjoy coming together and talking about voting rights and election law because I find it a very interesting area of law. And also to be here with State Representative Mike Colona, with whom I've had a very long history as well. So I'm here to talk about voting rights, and we decided that I would kick it off tonight by talking a little bit about history. We were asked to talk a little bit about the Voting Rights Act, and just to sort of bring some context to some of the contentious voting rights issues that we're facing in this country today. And I'll just sort of spin around over the course of the hearing. But not only are we in the midst of a highly contentious and historic election cycle, but we're also really in the midst of a lot of open questions about the nature of the right to vote, both at a national level and even right here in Missouri, where we actually have a measure on the ballot this November that affects the nature of the right to vote in our state. And so these questions are really, really relevant. This is going to be the first presidential election in 50 years without the full provisions of the Voting Rights Act in place. And there are new voting laws in place for the first time in 14 states around the country. And so this is all going on while there is a sort of swell of litigation in states around the country, challenging voter ID laws, challenging voter registration purges, challenging a host of other voting practices. So it's a very interesting and timely time to be talking about voting rights. And so I'm going to kick us off by talking, okay, let's just do this, about kind of the nature of the right to vote. I like to sort of step back, and I'm going to wear my professor hat a little bit, and think about sort of what is voting really all about? Because that helps us understand how these laws have come about, and it helps us understand how courts have thought about these laws, right? And I like to think of our vote as being our voice, right? It's the legal structure that our government has created that kind of gives us a voice. Right? And even as far back as 1886, the United States Supreme Court has sort of reflected on that idea, saying that the right to vote is fundamental because it is preservative of all other rights. And I think what they meant by that is that it is the vehicle that gives you a voice to speak out and assert your rights in all these other areas. And so I want to kind of take us into how the Voting Rights Act got passed and how it got up to the point where it got changed significantly thanks to a 2013 Supreme Court decision. And then Stephen's going to come in and talk a little bit about sort of how some of the issues that the Voting Rights Act has addressed, and then we'll bring it all home to sort of what's going on right now. We give a lot of lip service to kind of being a robust democracy in this country, but of course our history doesn't really bear that out. When this nation was founded, only white male property owners had the right to vote, and there were a variety of restrictions in place, and the notion at the time really didn't have a lot to do with voting being sort of part of the social contract, right? That it was really more about who in the community is in the best position to kind of make the decisions for everybody else, right? And it really took the Revolutionary War to provoke a rethinking of that, right? The no taxation without representation sort of provoked this idea that, oh, well, maybe really voting has something to do with this social contract, the exchange between the government and the governed, a way of accountability. But our history is fraught with all kinds of restrictions on voting, not just based on gender, right? Women have not had the right to vote even for 100 years, and not just on race. At the beginning of our country, there were even religious restrictions in some of the colonies. We had residency requirements that were very lengthy at some points, requirements that had to do with whether you owned property or had a certain amount of wealth, the idea being that people who were dependent on the state sort of lacked enough independence to kind of make credible decisions. Yes. Thank you. And do, yes, please jump in, other panelists. And so, of course, voting the nature of voting was, of course, also what brought us to the Civil War, right? Is this actually going? I see. This is why. I just noticed that, right? The whole notion of citizenship, and what does citizenship confer? It confers voting rights, right? And Missouri has really been a flashpoint, in fact, on sort of the nature of what is voting for a long time. We entered the Union as a slave state amidst the fight about whether African Americans had the right to vote. The Dred Scott decision, the Dred Scott trial took place right here in St. Louis that resulted in a Supreme Court ruling concluding that African Americans in 1857 weren't citizens, not guaranteed the right to vote. And even women's suffrage had a major court decision right here from Missouri, a case called Minor versus Happersett, which involved a woman named Virginia Minor, shortly after the Civil War, who attempted to go vote in the city of St. Louis and was turned away. And her legal challenge to persuade the court that her citizenship conferred voting rights was also unsuccessful. So after the Civil War, we passed 3 amendments that are commonly bulked together as the post-Civil War amendments that are thought to confer citizenship and then voting rights, particularly for newly freed slaves at the time. Like I said, Virginia Minor thought that those rights should apply to her as well and filed a lawsuit under the 14th Amendment, but she was unsuccessful at that time. And these amendments together, the 13th Amendment, which abolished slavery, the 14th Amendment, which conferred citizenship and guaranteed equal protection under the law, and the 15th Amendment, which provided that the right to vote can't be abridged on account of race, really provided the underpinnings for a very, very different way of thinking about voting. And the result, as a practical matter, was that it expanded the electorate considerably. And this is a really fascinating time of history, this Reconstruction era. I mean, think about it. In the South, the African-American population that had been enslaved comprised a significant portion of the population. In some states, even a majority of the population. And so now, armed with newly granted citizenship rights, thanks to the 14th Amendment, they could vote. And they did. And what's truly incredible about this era is that they actually got elected to office in significant numbers. This is within a decade after the end of the Civil War. You had over 600 people elected to state legislature, 600 African Americans, a decade after the end of the Civil War, who got elected into state legislative positions. 16 African Americans in Congress. It's really, truly phenomenal.
Do they know what states they were coming from?
Yeah, I mean, and a lot of these actually were in the South, because those places like North Carolina and South Carolina actually had majorities African American populations, and you had a fairly decent contingent from those states. Other southern states had, a near majority, and so when aligned with other interest groups, were able to secure enough votes to get elected. And this is really, truly phenomenal, 16 African Americans in Congress, because 100 years later, the year before they passed the Voting Rights Act, the number of African Americans in Congress was 3. And what happened in between is really important to understanding why the Voting Rights Act got passed. Right? And this is a rendering of a part of the congressional delegation from that time. But this was a short-lived era, right? Most people say about sort of 12 to 15 years or so, is that about right? And it was met with a great deal of resistance. Not surprisingly, being so close to the Civil War, the South that had fought the Union was very resistant to these changes. And so what you began to see was sort of extra-governmental intimidation at the polls, even violence. The KKK became quite, their membership grew considerably during that time. And other organizations like the Red Shirts in North Carolina, the White Liners in other states, really engaged in a lot of activities that while didn't legally prohibit African Americans from voting, made it very difficult for them to do so, engaged in a lot of intimidation and terror tactics at polling places that really discouraged participation. And then that was followed shortly thereafter with a slew of legislative proposals, particularly in states around the South, to enact new laws that regulated the voting process. Because the Constitution now made it illegal to expressly discriminate based on race, these laws really had to be racially neutral. But they had an effect of making it much more harder for African Americans than it did for white voters. Though many of these laws had similarly problematic effects for poor white voters, I should note. And this slew of legislation, some of it was challenged. Some folks said, hey, well, we have the 14th Amendment now. We have the 15th Amendment now. But those challenges were generally unsuccessful. By and large, the courts concluded that states had a right to regulate voting and that these kinds of laws like poll taxes or new voter registration requirements or lengthy residency requirements didn't sort of rise to the level of a constitutional violation. And so what you began to see shortly thereafter was a move to start changing state constitutions. And between like the 1890s to the early 1900s, 10 of the 11 southern states actually changed their state constitutions to enshrine some of these voting requirements in an effort to shield them from further legal challenges. And these included provisions like poll taxes, and I'm not going to go into these in great detail, but there's a list of some of the states, for example, that had poll tax implementations. And sometimes this was combined with a literacy test. A poll tax was something where you had to pay a particular fee, either at the time you registered to vote or at the time that you cast a ballot. Education requirements, which are often known as literacy tests, where you had to demonstrate some sort of level of knowledge sometimes about the process, but sometimes the education requirements were not really related to civics at all. Some of them were kind of bizarre and nonsensical. There's kind of a well-known example of voters being asked how many bubbles in a bar of soap, right? And very often these types of tests, whether you passed or not, were left to the discretion of whoever was administering the test. And these were often combined with grandfather clauses, which exempted people whose grandparents were able to vote from having to take these tests, right? And so in several decades after the end of the Civil War in the South, whose grandparents were allowed to vote. Maybe a few African Americans who had been freed prior to the end of slavery, but by and large, it meant that African Americans had to take the tests and many whites did not. And again, these were challenged in court, but largely these sorts of challenges were struck down. And this actually led to the organization of the NAACP in 1909, which was formed to start bringing legal challenges to some of these voting laws. And the impact on the voting population based on race was really significant. And this is just one example in Louisiana, which in 1896 had 130,000 African Americans registered to vote. And they changed their constitution in 1898 to add two of those provisions, the literacy tests and the grandfather clauses. And by 1900, fewer than 5,000 African Americans remained on the rolls. And a decade later, only 730 remained on the rolls. And those numbers didn't change markedly until after sort of the second wave civil rights movement, after Brown versus Board of Education kind of ushered in the that next wave of the civil rights movement. And so you can start to see now why those numbers of people in Congress in 1964 were so much smaller even than they were 100 years earlier. And so that kind of, we're just jumping right ahead. And so as Brown versus Board opened up this kind of cultural drive to expand civil rights, and one of the themes I want to suggest to you is that these legal issues are so deeply intertwined with political movements, cultural movements, social movements. You really can't extract the two. And when you see changes in how laws get drafted or how laws are interpreted by courts, there's very often a social and political context behind it. And so Brown versus Board opened up a new era of thinking about how does the law address issues of discrimination based on race, right? And so Brown, of course, found that separate but equal was a violation of the 14th Amendment with respect to education. And so at that time, though, literacy tests were still on the books, poll taxes were still on the books, and there was an effort to try and pass legislation to address these things. But that legislation, things like the Civil Rights Act of 1957, really fell short, even though it authorized the federal government to start suing states that they thought were engaging in discriminatory practices. But it turned out, even with amendments to those laws, that those lawsuits were really hard to bring, and they're really hard to prove. And in fact, that remains very true to this day. I'm sure Stephen and I both are involved in a lot of voting rights litigation, and they are massive undertakings in order to prove up these facts. And that proved to be the case that even when the federal government was armed with the right to sue states that were, to try and challenge, say, literacy tests. Well, how could you prove that a literacy test was racially discriminatory if it presumably applied to everybody? We would have to show that it was being applied in a harsher manner to certain populations compared to another. Well, to prove that meant that the government had to go through a highly laborious process to go through example after example after example after example. And it didn't really work. And then Congress passed a massive civil rights bill known as the Civil Rights Act of 1964, which prohibited discrimination in housing, employment, public accommodations, but didn't really touch on voting. And even though Lyndon Johnson, who was president at that time, believed that the federal government needed a little more heft to enforce voting laws, he thought, we kind of went far enough with the Civil Rights Act of 64, and he was a Southern president and really needed to maintain that base and decided not to push his bill forward. And that's where culture and politics comes in, because it put pressure on both President Johnson and Congress to move that legislation forward, pressure that might not otherwise have existed. And so the civil rights movement combined with the expansion in media, television, really provided a groundswell of pressure that pushed Congress to move forward. Freedom Summer, where students from across the country, particularly the North, went down to Mississippi and the South to register people to vote and hold freedom schools, was proved to be very compelling media for folks. And at the same time, the resistance and the violence that many of those folks faced when undertaking these projects also proved to be very compelling to people, right? And of course, the violence was profound, including murders of Andrew Goodman, James Chaney, and Michael Schwerner. And that opened the door to Selma, the march on the Edmund Pettus Bridge. That's a young Congressman, John Lewis, in that photo. right? And the visual images of John Lewis getting beaten up on that bridge really was the catapult that pushed the Voting Rights Act forward. And a week later, President Johnson addressed Congress in a very famous presidential address that even evoked some of the hymns of the civil rights movement. He concluded his address with the words, "We shall overcome." And it worked. And later that year, Congress passed the Voting Rights Act. And really, in essence, what the Voting Rights Act does is codifies the 15th Amendment that says the right to vote shall not be abridged on account of race. And in fact, it mirrors Section 2 of the Voting Rights Act, mirrors that language very, very closely. And you might think, well, why did they need federal laws if the Constitution already prohibited it? But that slew of court rulings didn't allow those parts of the Constitution to be invoked to challenge things like literacy tests and poll taxes. And so that's where this federal legislation came in. And so Section 2 applies across the country. It prohibits any voting practices that have a racially disproportionate impact. The Voting Rights Act also ended the use of literacy tests that were still in place in a number of states. I recently finished litigating a major voting rights case in North Carolina, and my lead plaintiff, who is currently 95, had to take a literacy test to register to vote over 70 years ago. So this is not such ancient history. That literacy test was on the books there until 1965. But one of the most kind of profound and impactful pieces of the Voting Rights Act, and the piece that Stephen's going to touch on in greater detail as well, is Section 5. It's also the most controversial section of the Voting Rights Act. And that was the part of the law that is known as preclearance. And it required states, not all of the states, and this is part of the reason it was controversial, but states that had a history of discriminatory voting practices could not implement any new voting changes until they were reviewed by the federal government or pre-cleared by either the Department of Justice or a 3-judge panel of the federal court in Washington, D.C., to determine whether they were racially retrogressive. And by that, the law meant, did this new voting practice place minority voters in a worse position than they were before? And this is a profound kind of law, right? This is the federal government telling states that they can't implement a law that they have passed until the federal government clears it. So it's a really substantial piece of legislation. And that is, in fact, the part of the law that is now no longer in effect after this Supreme Court ruling in 2013. And so these are the jurisdictions. This part of that were covered by that law that said that they had to submit new voting changes. And it applied no matter how big, how grandiose, or how minor the voting change was. So even something like changing how city council districts are set up, moving them from, say, ward elections to at-large elections. Even that would have to be submitted to the federal government. And so you can see that not all of the states were affected. But there is a really interesting juxtaposition between the states that were covered by the Voting Rights Act preclearance provisions and states that had voted to secede from the Union or had slavery during the Civil War. The dark red had seceded by 1861, and the lighter red seceded after that, and the yellows were slave states that didn't secede. And so, when you think about sort of the legacy of how voting happened in those, particularly in those southern states, perhaps that offers some context as to why those states were on the map. But it certainly isn't without controversy, right? Because that opens the door to, well, why those states? That may be unfair. And here's another interesting thing about the Voting Rights Act, and I don't want to spend too much, I want to open the door and let the other speakers talk, so I'm going to whip through this real quick. But the Voting Rights Act originally had a 5-year expiration date, which is sort of interesting to think about now. Over 50 years later, we're still really, really conflicted about the state of voting rights. So it's sort of interesting and perhaps naive of Congress to think that a 5-year window would have kind of fixed all that stuff. But Congress decided to renew it in 1970, and they added new provisions. They lowered the voting age from 21 to 18. By that time, we were in the midst of the Vietnam War, and there was a lot of social and political pressure. Hey, if I can go fight in this war, I have a right to vote, right? They extended it again in 1975, and they extended the list of states that were covered, and they also added provisions relating to language minorities. And so there are some jurisdictions in this country that have to provide, say, like bilingual ballots, where there's a substantial population of certain non-English speakers. And in 1982, they extended it again for 25 years this time. And they put in a provision that said, okay, there has to be a way for some of these states to get off the list. All right? And that was known as the bailout provisions. And so that was a provision that said, if you have sort of had 10 years without a finding of a discriminatory voting law, you can get off the list. And you no longer have to abide by this. And in 2007, which was 25 years later, the Voting Rights Act was renewed yet again. And there was a little bit of controversy, but nothing like we see today with respect. It was renewed by a bipartisan Congress signed by President Bush, and that is the provisions that's in effect today. And the impact of the Voting Rights Act really was profound in affecting the American electorate. And these are just some of the, even a year later, only 4 of the 13 southern states had less than 50% black registration. And here's some of the numbers. Within one election cycle in Mississippi, black voter registration went from 10% to 60%. In Alabama, 24% to 57%. Really profound numbers, right? And those numbers, of course, have an effect on the outcomes of elections. And had the effect of generating more elected officials of color as well. And ultimately, the election of our first African-American president. And I'm going to skip all these cases right here and stop here. But what I will say about this is that the authority of Congress to pass this law was challenged almost immediately. But unlike the post-Civil War, this time the United States Supreme Court said that it was within Congress's authority to regulate voting in the states where there was a history of discrimination that needed to be remedied. And indeed, many of the other provisions of the Voting Rights Act were also challenged in court. This was a very, very prolific time for voting rights lawyers, these few years after the Voting Rights Act. That involved literacy tests and poll taxes and a whole host of other provisions, residency requirements, all made their way up to the United States Supreme Court. And that gets us to sort of modern times where things were sort of quiet for a while. And in the last sort of few years, we've begun to see a real resurgence of legislation that affects voting. And more so than at any other period in our nation's history. And indeed, you can see that just in 2011 alone, a significant number of states, 34 states, introduced photo ID laws. A number of them passed, but those with the red dots or red stars were blocked from going into effect. Many of them because of the Voting Rights Act or other legal challenges. And the next year, even more legislation was passed. And that all leads us to the Supreme Court taking up a challenge in June of 2013 from Shelby County, Alabama, where Shelby County argued that the formula for deciding which states had to submit those voting changes was outdated and unconstitutional. And ultimately, the Supreme Court agreed with that. And I know Stephen's going to talk about that case a little more, so I won't go into great detail. But ultimately, that's what the Supreme Court said, was this coverage formula doesn't work anymore, that it's no longer responsive to current needs. And they struck that down. And while they didn't actually talk about whether Congress had the right to require states to submit voting changes, the fact that there was no formula for deciding which states had to do it meant that no states had to do it anymore. And immediately, even that very afternoon, Gregory Abbott, the Attorney General of Texas, whose photo ID law had been blocked as racially discriminatory under the Voting Rights Act, announced that that law would be going into effect. And it did. And Alabama and Mississippi followed suit, followed by the passage of the first law, voting law, after the Shelby decision in North Carolina, which was the case that I litigated. And I think I want to sort of stop at that, because I've been talking quite a long time. And that sort of, I hope that sort of gives a little bit of a context to sort of how we got to where the Voting Rights Act kind of is today. And I think it might be good for, I know some of you have questions, but Stephen's an expert on the Voting Rights Act as well, and so I think it might be good to bring him up, and I don't know if you want to take questions now or if you want to let him talk and bring it in, but if we do take questions now, he should be part of it too. We're not done. We're just getting started. I think this might be I think this is a nice segue to bring Stephen into the conversation. So why don't we wait and do questions later, if that's okay?
That's good.
Okay.
Perfect, thank you. Well, if this is on. All right, well, certainly happy to take any questions. As Denise mentioned, she and I have appeared multiple times at bar events kind of on opposite sides of these issues. So I will give you I'll just admit that I have a more conservative perspective on these issues, especially voter ID. Denise has appeared on behalf of people suing states, saying that the photo ID is discriminatory and violates the Voting Rights Act. I've appeared on the opposite side defending a state. Of course, those laws are different. They differ by state, and certainly Missouri has, as she mentioned, a law on the ballot next Tuesday that we'll have Representative Colona maybe talk about a little bit, since he has firsthand knowledge of that. But I'm going to just tread lightly over some of the same ground that Denise went over, just because I think it's so important, and repetition is good to learn by. She mentioned the post-Civil War amendments to the Constitution. We've got the 13th Amendment, which abolished slavery, the 14th, which she said made everyone a citizen of the United States who was born in the United States or naturalized, and then ensured equal protection of the laws to all citizens. Then you have the 15th Amendment, which said that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. And each one of these three amendments included a provision at the end enabling Congress or allowing Congress to enforce these provisions by appropriate legislation. So that's where you have, I think, the real difference between pre-Civil War and post-Civil War voting rights enforcement in the United States, is that pre-Civil War, the states really had pretty much total control over voting regulations in this country. And then you see after the Civil War, we have these new amendments. We changed the Constitution to give Congress authority to regulate voting rights in state and federal elections. So, as Denise mentioned again, the Voting Rights Act, Section 2, this is Section 2 of the Voting Rights Act, is one of, it's kind of the central section. It basically codifies the 15th Amendment and says no voting qualifications or prerequisite to voting or standard practice or procedure shall be imposed or implied by any state or political subdivision in a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color. So not only can a state not pass a law that intentionally discriminates, a state also cannot pass a law, or it can be struck down under the Voting Rights Act, if it results in a denial or abridgment of any rights. And that's where we see kind of the sea change in litigation over the past few years, where first we have the Crawford decision in Indiana about photo ID. That was decided under the 14th Amendment. Now we see a bunch of cases in states challenging photo ID on the basis of the Voting Rights Act, not just the 14th Amendment. And so a judge or a court has to weigh whether photo ID or other voting regulations have the effect or the results in the abridgment of any voting rights. All right. Again, literacy tests. These are great products of the Voting Rights Act is the abolishment of literacy tests and poll taxes. So you have literacy tests that ask questions like, after the presidential electors have voted, to whom do they send their account? So you go in to register to vote, and this is what they ask you. They ask you a slew of questions kind of like this. And you think, well, I could maybe, if I studied, pass that kind of test, especially as we're coming up on an election, who do the electors submit their votes to? I think it's the vice president. I have to look. Does anyone know? I don't know if I would pass this test. But then you have a question like this: spell backwards, forwards. Like, okay. I think they're trying to trip me up. Print the word vote upside down, but in the correct order. Okay. Maybe I could pass that test. Draw a triangle with a blackened circle that overlaps. These kind of questions. There's lots of these kind of questions. It's kind of fun if you go on the internet and you Google literacy tests, you get a whole slew of these questions that are actual questions on old tests, which is funny and sad at the same time that they would do this. Okay, then they would ask you to maybe recite the preamble to the Constitution or a section of a state constitution. And a white voter would be asked to recite and write down one line. And an African-American voter would be asked to recite and write down this and interpret the meaning of it, which there's no way I could pass this test, even before, during, or after law school. Okay, so those are literacy tests. Poll taxes. They were abolished in federal elections by the 24th Amendment, just before the Voting Rights Act was passed. There's what the 24th Amendment says. And then they were abolished in a Virginia case, Harper versus Virginia Board of Elections. Okay, now what I'd like to get to is kind of like what we do in law school, talk about some cases. I won't get too into the weeds on these because then it gets kind of boring, but in a law school class, you'd bring up a case, you'd say, okay, you call on somebody who can explain what this case is about. And who can explain what the court said? So any volunteers? I'll just go through them quickly. Let me know if you have any questions. So first off, Denise mentioned the Shelby County case. So Shelby County, Alabama. It was decided in 2013. It was a controversial decision, 5-4. You think that's why we have 9 members of the Supreme Court, so we can have these 5-4 decisions? What happened? Right. Right, and okay, I won't get into that, but yes, we currently have 8 members of the Supreme Court. So the court has, you can see that the court has stayed away from more controversial issues because it can't come up with a decision. And if there's a 4-4 tie, then it just means that the lower court decision stands. So there's a current case out of Missouri, Columbia, where I grew up. It's called Trinity Lutheran Church of Columbia versus Pauley. It's a religious liberty case. My firm, we submitted an amicus brief. We're not the litigants in the case, but we submitted a friend of the court brief to the Supreme Court. And we submitted it at the 8th Circuit at the appellate level, and then at the Supreme Court when the Supreme Court accepted a review of the case. So it's a religious liberty case again, where it concerns. Anyone heard of this case, Trinity Lutheran Church? It's going to be a major decision if it ever gets decided. It's again, as a religious liberty case, it can be thought of as a controversial case. People expect it to be kind of a 5-4 decision when the Supreme Court finally gets to it. What happened is, when Justice Scalia was still living, the Supreme Court accepted the case. And then after that, of course, Justice Scalia passed away. So since then, the court, of course, we don't know what the court is doing or thinking because it doesn't tell us very much, but it has postponed argument for months and months. And I think everyone kind of thinks it's waiting until we get a 9th justice so that they'll say, okay, now we can hear the case and make a decision because it's going to be close. So it has to do with rubber pellets on playgrounds and whether that is allowed under Missouri's Blaine Amendment. Missouri has a couple parts of its state constitution. I always try to have my state constitution on me. So you can get this free from the Secretary of State. State Constitution. At the beginning of my classes, I always bring a stack of state constitutions and give it to and I make them take it, and they're like, I don't want this thing. So Missouri's state constitution says no public money can go to aid of a church. And so Trinity Lutheran, I'm getting off topic, I'm sorry. Trinity Lutheran Church runs a preschool, and its preschool has a playground which has rocks on the playground surface, and they want to have a nice safe playground with rubber pellets, and the state provides rubber pellets, but the state won't provide rubber pellets to this preschool because it's run by a church. So this issue is going up. It's a big First Amendment case going up to the Supreme Court. But because they only have 8 members, they won't argue the case yet. So we're looking forward to that. And where was I? So Shelby County was a 5-4 decision. You can see that the majority was composed of the court's more conservative members, and the dissenters were the more liberal members of the court. And as Denise said, they said, Justice Roberts, Chief Justice Roberts said, you know, the coverage formula, Section 4B of the Voting Rights Act, has been in the Voting Rights Act since 1965 with minor tweaks, that if you're going to impose upon state sovereignty, then you need to justify it with current needs, not past needs. And during oral argument, they had lots of questions about how voting rights have increased among minorities since the passage of the Voting Rights Act, and how things are different now than they were back in 1965. And the court said, the majority said, all states are presumed to be equal, on equal footing. So in order to treat states differently, like Section 4 and Section 5 do of the Voting Rights Act, where you have those covered jurisdictions of mostly southern states, we treat those states differently. So if you're going to treat those states differently, then you need a current reason to do that. That's basically what they said.
Would that be considered liberal judicial activism?
No. No, well.
So precedent was that, again.
Well, Congress has the authority under the 13th, 14th, and 15th Amendment to enact appropriate legislation.
Okay.
So you have the majority of the court saying this is no longer appropriate because it doesn't apply to today.
So it was liberal judicial activism.
No. Okay. So again, the question was, does the renewal of Section 5 of the Voting Rights Act under the constraints of Section 4 exceed Congress's authority? And the majority said yes. But the court left up to Congress. If you think this is still needed today, then just reenact it today. So that would be the answer. It didn't.
Same way
It doesn't.
they reenacted it last time?
They would reenact it to fit today's needs. And we see.
Oh, it includes voter ID stuff.
If it shows. Okay. Thank you. So you want to come up here? All right. So I'll just breeze through this. I summed this up. The court said, despite tradition of equal sovereignty, the act applies to only 9 states and several additional counties. When we first upheld the act in 1966, we described it as a stringent and potent remedy, but we recognized that it may have been an uncommon exercise of congressional power, but concluded that legislative measures not otherwise appropriate could be justified by exceptional conditions. Yes, sir.
The bailout provision address what you might call current needs. The state could get off the roll by good behavior.
A state could, but what is good behavior? I mean, is that...
No challenges to their attempts.
Right. Right. But so you have any state law or regulation that affects voting rights in those covered jurisdictions that has to be submitted to the Department of Justice. So I'm assuming you'd have to go 10 years. 10 years without the Attorney General objecting to anything.
No, you only have to go 10 years since anything was upheld or not upheld.
Right, in the past 10 years, the Attorney General has not...
Not just the objection of the Attorney General would be a court saying, forbidding the...
I'd actually have to turn that over to Denise, I don't know.
It actually, Stephen's right on that. What the preclearance provisions required was that states had to submit any new voting changes to either the Department of Justice or a 3-judge panel of the federal court. And so either one of those two parties could make a conclusion that the law was racially retrogressive. And when the Department of Justice made that conclusion, it was called an objection. When the court made that conclusion, it was called a judgment. Now, the states did have the ability to sue and challenge that, so that's actually what happened in Texas. Yep. Texas submitted their law, the government objected, and then Texas filed a lawsuit, and then after that, the court concluded that the law was racially retrogressive. But
right, I think
he was right. So it was 10 years.
What you have in
with
Shelby
no
County too
objections.
is you have Shelby County suing, saying we want to bail out. Now, if you think of it from the perspective of one of these states, we've been under this provision for 50 years, and the Attorney General at any time can object to any voting regulation. So it's going to be impossible or nearly impossible for us to bail out. So instead, what these states often do is they end up suing in that 3-judge court in the District of Columbia, which is what Shelby County did. And it ended up in a change in the law. Yes, sir.
Jumping forward just a little bit, it would seem that the issue today is voter ID.
Yes.
Some would say photo and so forth, but taking voter ID broadly,
Right.
suppose the federal government undertook to issue voter IDs and distributed them by an equitable fashion, which I'll mention in a moment. And you go to vote, you turn in your voter ID, and it's gone until the next election, or until the government issues IDs for the next election.
Now, you could have the federal government impose that for federal elections.
Right. Okay,
And it does that under HAVA. You'd say correct.
And I have thought of a proposal and discussed it with some other people. It boils down to 4 words, and that is that you would issue these cards to the people that have filed income tax returns, whether they pay taxes or not, just file the return. And my four words are no representation without taxation.
That's an interesting proposal.
That's as far as it'll go, but it's.
Yeah, well, let me talk about the Crawford decision briefly, and we'll get into photo ID more. Yes, ma'am.
Just on a broader term, I'm wondering why this has become such a big bone of contention now, and whether it may have to do with the fact that the white population in the U.S. is being or fearful of the Hispanic and the other minority groups who are eventually going to be the majority if they aren't already.
Well, you certainly hear those allegations. What conservatives who are generally in favor of these laws say that we want to prohibit voter fraud, and that photo ID is one method of doing that. And maybe I'll just say this and we can take a break and then get into more photo ID after. But there was, and litigants like me hang our hats on this. There was a commission called the Carter-Baker Commission, and it was chaired by former President Carter and James Baker, former Secretary of State. And they issued a report in 2006, and one of their proposals was that there should be a national, or states should provide an ID, a photo ID, or the national government could provide a voter ID.
Well, if they check your penmanship, your handwriting when you go in.
They are supposed to check your
and
signature.
You can also computerize and change somebody's photograph. I fail to understand why that's such a big deal.
Well, that's the question. Is initially when the Carter-Baker came out with that recommendation, or when they were discussing it, I think it was not looked on by most people as controversial. But then, as they began discussing it more, it kind of more people objected to it. Yes, ma'am.
Well, isn't one of the, or maybe the biggest objection to the photo ID, the difficulty that some people would have getting it?
Absolutely.
And so if the federal government or the state government was going to issue it, you know, it could be different, but that would be expensive.
Right, absolutely. That's what Denise was talking about, and what we litigate about is the expense of getting them and the difficulty that people have in getting them. So maybe, do we want to take a break and then come back and cover voter ID? Is that okay? Let's go ahead with our break then.
10-minute break.
Well, I had a suggestion that to go ahead and present the rest of the material, and then we'll take questions. And maybe we can narrow down the questions. And I could bring on the legislator, yeah.
My presentation's short.
And what I think I'll do is I'll touch on gerrymandering really fast and then come back to photo ID to just kind of explain what that is. And then we can end with photo ID, and I'll turn it over to Representative Colona. Okay, so this is the famous gerrymander salamander, if you can see that, where the word gerrymander comes from. Elbridge Gerry was the governor of Massachusetts. He was also a signer of the Constitution, I believe, Declaration. And he got the blame for gerrymandering, which I don't know if it was his fault or not, but it landed on him in Massachusetts, creating a district that was shaped like a salamander. So I ran across this in the Washington Post. It's a great explanation of what a gerrymander is and why legislatures do it, legislators. So imagine you have 50 people living all together, and you want to split them up to boost the minority's representation. And so normally you think you divide a state up, and the majority, if it's a majority Democrat state, you think there'd be more Democrat seats than Republican seats. So imagine here the red people are Republicans and the blue are Democrats. You've got 20 Republicans and 30 Democrats all in a state. How would you divide them up? See, well, this would be perfect representation where you have all the Republicans represented by a Republican member of Congress. And you could do this. These are compact districts. They're not gerrymanders, but they're not fair because it splits up. You have no Republican districts. But if the Republicans take charge, they can do this. Even though they constitute a minority, they control the majority of the seats. So that's.
Is that what happened after the Red State Project?
I don't know what you're talking about. So here's Missouri. Here are the current Missouri congressional districts. See any salamanders in there? Any gerrymanders? I don't know. Yeah, it's hard to. Well, yeah, it's hard.
Let's take a look at
I'll just say no.
Is the toad there in Kansas City?
The Kansas City, is that what it is? A tail or a toad? They call it a toad?
Yeah.
Yeah. A Jackson County split there. Okay, here are some from other parts of the country. Some of my favorites. The one in the lower left has been called the Pinwheel of Death. That's in Maryland.
On a serious note, were districts like that challenged and
This Pinwheel of Death, the Maryland district is currently on appeal to the Supreme Court. And this next one in Virginia, the 3rd district, southeastern Virginia, you can see Norfolk and Virginia Beach down there. This is Bobby Scott's district, and it crosses, water. And it's currently before the Supreme Court, so it'll be. The Supreme Court has said the Constitution says that districts must be compact and contiguous, but then the Voting Rights Act, okay, let's get into what the Voting Rights Act says in Alabama Black Caucus.
Because most of these are getting challenged under the Voting Rights Act, right?
Right. So Denise mentioned retrogression. So Section 5 of the Voting Rights Act prohibits retrogression, meaning you can't have a change in a voting law, like a district, that hurts a racial minority more than the status quo. Is that how you'd explain it? You can't retrogress. I don't know why we don't say regress, but you can't retrogress to make it harder for African Americans to vote or be represented by a candidate of their choice, of the minority's choice. So when you redistrict a state, you have to keep those minority districts intact. It's kind of a baseline. You can't make them worse. So in Alabama, in their state redistricting, they had 8 majority black Senate districts and 27 majority black House districts. They redistricted the state, and the now Republican legislature redistricted so that it kept the minimum, and then they moved black voters into those majority black districts to make the population more equal across the state among districts. So all the districts in the state, and congressional districts in the state, they all have to have equal populations. Missouri's 8 congressional districts all have equal population. The state legislative districts, they need to be, the Supreme Court hasn't quite said what the standard is, they need to be as nearly equal as possible, as practicable. So there can be, there's debate on that, there can be a deviation between legislative districts of up to 10% without the courts getting involved. So what Alabama did is they said, we're going to keep it within plus or minus 1%, a 2% deviation among all state legislative districts. And to do that, because they were unequally populated, they had to move voters into districts.
So, gentlemen, let me ask you a question right quick. Is that another way of saying we're going to make black districts more blacker and more heavily Democratic so that we have a better opportunity of having wider districts with Republican representation?
So when they had
take some of those Democrat seats away
so
from
what
Democrats.
in a way, so if they had a 70% African American district, they said Section 5 compels us to keep it at 70%, right? So then they moved more black voters into that district to keep it at a 70% district, like an ultra majority-minority district. And by doing that, you keep the same number of black districts and you have more Republican districts in other places, right? And the Supreme Court said in this case, Alabama Black Caucus, you can't just do that. You can't just have a formulaic, keep everything at the same level. You have to look at what they say. It can't be a mechanical view of maintaining majority-minority districts at prior level. That's not a correct standard. Section 5 requires the legislature to maintain a minority's ability to elect a preferred candidate of choice. So the legislature now, if you have a 70% African-American district, you can't just keep it at 70%. Republicans can't just say, we're going to keep it at 70%, and to do that, we have to move in more minority voters. The legislature has to look at what does it take for that district to elect a candidate of its choice. And it may be 70%, it may be 51%, somewhere in there. But you can't just keep it at the prior level, right? And the court said that attaining that equal population is not an excuse to change the racial makeup of those districts, right? So it made it a little more complicated to redistrict. I don't want to get too in the weeds on that, but too late. Okay, back to photo ID. Does anyone have any? Well, let's wait on questions. Let's wait on questions for. But I'll be happy to take questions on photo ID and gerrymandering. Oh, Representative Colona will be in just a minute. Okay, so Crawford. Where did Crawford go? After Shelby. Okay, after Shelby. Right, Crawford. All right, so Crawford is 2008, and it was Indiana passed a photo ID law so that you had to have an Indiana state ID to vote, and there was no provision for providing those IDs free of charge. So the Democrats sued under the 14th Amendment, saying this is a poll tax. I mean, Denise knows more about this case than I do, so jump in anytime. They alleged under Harper versus Virginia that it was an unconstitutional poll tax. But the Supreme Court broke apart. There was no decision of a majority of the court. There's no opinion of a majority, so they broke, I think, 3-3 and 3. So you had Justice Stevens' plurality saying that even though there's no evidence of voter fraud, the state has a compelling interest in regulating its elections in such a way as to combat voter fraud and to maintain the integrity of the electoral process. And it looked at this Carter-Baker Commission report that I mentioned before, where you have a bipartisan team of people making suggestions, and one of those being we should have photo ID. And the commission said that even though voter fraud is not widespread, and it's debated how much there is, it does happen, and that in narrow, very close elections, it could potentially make the difference. So that was, the commission thought, enough of a reason to propose a photo identification. And that's what you see states doing. Saying that even though there might not be rampant voter fraud, there is voter fraud, and we're certainly, I think, expecting a close election this time. We'll see how it turns out. Let me get to questions in just a minute. Okay, and Justice Stevens said, for most voters who need them, the inconvenience of making a trip to the Bureau of Motor Vehicles, gathering required documents, and posing for a photograph surely does not qualify as a substantial burden on the right to vote. And you had even Justice Scalia wrote another opinion saying this is not even an inconvenience. This is just a non-issue. you need a photo ID to do anything today. So, but then you had the dissent that said, hold on, it can be a burden. The legislature passed a law in Missouri. Do you want to?
So let me hop in here right quick.
Okay.
We're at 20, and
Yeah.
I promise I'm only going to take about 10 minutes of your time. Is this thing working? Yes. I promise I'm going to take about 10 minutes of your time and then open up for questions. Gosh, a lot of stuff going on here. And I just want to give you a little bit more about my background and kind of why I'm here and what it is I can add to this. I guess I've been practicing law for about 22, 23 years, and I've been in the General Assembly for 8. And I truly love both jobs. And listening to these two guys get up here and do their thing, it reminds me why I love both my jobs. Number one, I love being a lawyer, because on the one hand, there's absolute right, and as a lawyer, you get to fight for that. It's theory. It's beautiful. On the flip side, as a politician, I got to deal with reality. I got to deal with, okay, your people, they have points on some issues. And your people, that would be left-wing, left-back Democrats, even more liberal than me. All right, well, they got a point too. So as elected official, we got to figure out, as you know, how to harmonize this. And this whole photo ID issue, I think it is an excellent example. Denise started by saying states after Reconstruction in the South changed their constitution so that they could legitimize some of these new laws that would discriminate against new voters. Well, on Tuesday, you're being asked to change your constitution so that we can now enforce photo ID. The case that I believe you were involved with in this back, the Weinstein decision, when Missouri passed its first photo ID law a number of years ago, the Missouri Supreme Court threw that out, not as a violation of our federal constitution, not as a violation of the Civil Rights Act or of the Voting Rights Act. They threw it out as a violation of the Missouri State Constitution. Our Supreme Court, our state Supreme Court, said that the Missouri Constitution gives you greater protection for your voting rights than the federal Constitution. And here we are being asked to change it. Now, on the flip side, my friends on the Republican side will point to some of the issues that were highlighted in some of the Supreme Court cases. Well, if you need a photo ID, is that going to cost you any money? And is that a poll tax? Well, you know what? We'll fix that. We're going to make it free. It might cost us, some folks will say 2.1 million, others will say 60 million bucks. I got to do what?
You can flip the bottom, we have on mute.
I don't have my glasses with me, so it's... Sorry. So that's a policy decision. Are we going to take money, I don't know, from preschool education and give it to the Secretary of State so they can issue voter IDs? You'll decide that on Tuesday. This whole issue that was argued in the past about, well, there are some folks, and actually constituents that I met going door to door, that don't have the documents necessary to go get a photo ID. And I'll give you an example. Well, just bring your driver's license. I don't want to shock anybody, but my stepfather at 57 is in an extended care facility. I can't find his driver's license. I'm his power of attorney. You know what the Department of Revenue told me about getting his driver's license? Bring him down. Seriously, bring him down? What if I've got, as I do, an 85-year-old constituent in a nursing home that doesn't have a birth certificate and truly doesn't have any state photo ID? How are they supposed to get a voter ID? Well, the majority party comes back and says, we can fix that. We're going to let your 85-year-old constituent sign an affidavit that says he or she is really he or she. And then they can vote. The flip argument is, well, if we're worried about this voter impersonation fraud, that would assume that we don't have safeguards in place that would make sure that you are you when you vote. And if you think about it, well, you went to vote, what ID did you bring? Well, I brought my utility bill. And I can see some people would say, well, that really doesn't verify that you are you. State law allows it, so I guess I'll let you do it. But what we don't talk about is Tommy or Susie, your election judges, have been your election judges for the past 4, 6, 8 elections. And they're part of that check and balance system. They know people. And if you're new, they'll scratch their head, but they'll check signatures now on the computers that they have at polling places. There are challengers from each party there that can challenge the credentials of a voter. So I can be the biggest partisan hack out there and snarl and growl and grumble. But I think one of the reasons I'm going to toot my own horn, been a successful legislator, is I'll acknowledge your other people's points of view and either debunk them or be taught a lesson. And I'm still trying to figure out why we do need a voter ID if we already have these safeguards in place. And what keeps coming back to mind is actually something that Stephen referenced, and that is these elections that we have sometimes are decided on razor-thin margins. Jason Kander is our Secretary of State because in true Chicago style, the city of St. Louis vote count didn't come in until really late and put them over the top. What, by less than 1%? I was one of the lawyers on the Franks versus Hubbard case. And I will tell you, this is my opinion, that case drives down voter participation in that district by at least 1%. You know, if campaign worker X came to me in the election and said, Mike, you going to vote absentee? Sure. And then I vote absentee. And then campaign worker from the other campaign comes and says, Mike, you broke the law. You can't do that. I don't know what you're talking about. Then Jennifer Joyce sends an investigator by and says, did you vote absentee? Now I'm not talking to you. And when we have the makeup election, I sure as heck ain't voting because I don't know if I've followed the law or broken the law. I have now been, in my opinion, intimidated because I'm not sure if I did it the right way to begin with. It's a difference between 4,300 people in that legislative district re-electing Penny Hubbard and then the special election having 3,100 people decide whether or not Penny Hubbard went back. Yes, ma'am. Oh, I'm sorry. Bruce Franks versus Penny Hubbard during the August primary. State representative from North St. Louis City. Thank you. Bruce Franks, the challenger, alleged that the incumbent, Penny Hubbard, nefariously abused the absentee vote apparatus to fraudulently obtain absentee votes and put her over the top. Penny won that primary election by 100 votes or so, but it was the absentee votes that put her over the top. She actually lost the in-person vote on election day. If you read the Post-Dispatch or you watched the news, you heard all about how the Hubbard machine just cajoled and squeezed and rattled and was nefarious, and that's why we had a new election. If you actually read the court opinion said there was no evidence of fraud. No fraud occurred. What happened is that, in the court's opinion, the election authority didn't follow state law on the handling of absentee ballots. You can vote absentee one of two ways. You request an absentee ballot, it gets sent to you in the mail. You have it notarized, you send it back. Or you can vote in-person absentee. In-person absentee is you go down to your election board and you simply vote in person. Another way to look at the way in-person absentee voting was handled, it was handled like early voting. State law says that with every absentee ballot, you got to stick it in an envelope and you have to have it notarized. Unless you're, say, a permanently disabled person, then you don't have to have it notarized. St. Louis City, St. Louis County, Jefferson, all of the metro areas on the in-person absentee weren't putting those ballots into envelopes and they weren't notarizing them. And those election authorities used another state law to say it was okay to do that. There's another, so there's one state law that says you got to put all absentee votes in an envelope and have them notarized. There's another state law that says, well, when it comes to voting stuff, you know, the Secretary of State is authorized to promulgate rules so that, you know, we make sure that we do it appropriately. Going all the way back to Secretary of State Blunt, when we received this money from the federal government, from this little federal act called the Help America Vote Act, HAVA, which said, here's some money, buy electronic voting machines, but if you're taking this money, you got to do it a certain way. You got to vote a certain way. The Missouri General Assembly, instead of changing the law, you know, sat on its thumbs and looked at the Secretary of State and said, well, you figure out how to do this. So again, going all the way back to Secretary of State Blunt, what they did is promulgate a rule that said, if you vote in person absentee, you don't have to stick it in an envelope, and you don't have to have it notarized. Primarily because you're using electronic voting machines, and how do you put an electronic vote in an envelope and notarize it? So the court, citing a 1916 Missouri Supreme Court case that says, you know, absentee votes, they aren't the real votes. The real votes are what you do on the Tuesday. Well, the election board didn't follow law, they didn't follow procedure, absentee votes aren't real votes, so new election. And ironically, that new election disenfranchised a third of the voters that voted in the first election. Now, that's my opinion. I did represent Representative Hubbard. I'm sure the attorney for Bruce Franks, who oddly has inserted himself in every single lawsuit of North St. Louis City politicians, Democrat versus Democrat, sometimes Democrats who were Republicans and are now running as Democrats to challenge Democrats. That attorney probably has a different opinion. I mean, and I would even argue that he's part of this, here's my partisanship coming out here, part of this effort to just drive down liberal votes to the point where you have a 1 or 2% margin that actually goes to the other party. And last observation I have, and then we'll open it up for your questions. I really kind of look at this whole voter ID thing and even what happened with the Franks Hubbard case, not necessarily as a, gosh, we got to suppress the vote of certain demographics. I really don't think even the most diehard Republican proponent of voter ID thinks that. What I really think, and this is just my speculation, is that there's this undercurrent of voting is a privilege. And if you're going to exercise that privilege, you have to do some stuff that entitles you to that privilege. And somewhere in between that thought and, wait, your right to vote is this sacred right that's constitutionally guaranteed, somewhere in between those two extremes, the argument is lost about how it really affects people. And I just go back to the Franks case. When you have somebody that has done everything they thought they were supposed to do to be able to vote, and then all of a sudden they're told, well, no, you can't do that, or now you need an ID, do you really want to make them jump through that extra hoop? Let's forget about that theory that we talk about in law school and argue in front of courts, and try and really focus on how it affects people day to day. You know, if your voter registration on this new photo ID, if it passes on Tuesday, if the address on that ID is something different than where you're presently living, should you be allowed to vote? Some folks are going to say no. Other folks will say, wait a minute, you expected me to take a day off of work, run on down to the election board and say, oh, by the way, I moved. And, you know, yeah, these are my kids behind me because, you know, I don't have daycare. And wait, what do you mean you closed 5 minutes ago and I got to come back tomorrow to change my address to vote? It's not the intent to suppress their vote. That's the practical application. And I think in the legal world we call that what, de facto versus de jure? Here's what I truly believe. I think for the most part, they're all good intentions. People want to do the right thing. Well, what do you mean by 50-50? But demographically, No, but I would venture to guess that there are more folks in former Representative John Deal's district of Ladue who can take the time to run down to the election board than in my district in South Central St. Louis City. If that makes sense. Yes, sir. I'm sorry. The photo ID, the way that we pass the law, it would be a separate ID that you use to vote. Now, some folks would argue, okay, so I need an ID to get on a plane, so I need an ID to write a check, so I need an ID to get into a movie theater, but my ability to ride on a plane and write a check and walk into a movie theater isn't protected by the U.S. and Missouri State Constitution. That's ridiculous, to be honest with you. I disagree with that. Hey, side note, gerrymandering, real quick. I was in Democratic leadership when we did this, and I'd be a little bit easier with it if it truly wasn't the stated intent of Republican leadership in the Missouri House to get Russ Carnahan. And by the way, let's talk to Emmanuel Cleaver and make his district much more safe and get his help so that his folks in the General Assembly would vote with the Republicans to get Russ Carnahan. I will always take my hat off to Congressman Clay. He did not play that game. Enough of that. Yes, ma'am. Sorry.
Question, okay, and don't get me wrong, okay, I'm not supporting this, okay, but whatever happens, okay, to, okay, long-term, practical, inexpensive, okay, ways, okay, of accomplishing something, okay, that is permanent, okay, that, you know, I'm not saying, okay, that.
No, I get it. I get it.
Okay, they can check my dog, they can check me, okay.
I get it.
Stay on your, okay, stay your bill. Okay, come and get your baby, okay, check it. There you go.
My opinion is that's never going to work. Because, and here's the reason why it's never going to work. That doesn't gin up my base. Oh, I'm sorry. The question, and I'm going to rephrase what you asked. Because I think what you were getting towards is, you know, with our history of learning what we've messed up in the past and how we've messed it up, why can't we get to this point where this is how things should work? It's working good, it's working smooth, and let's leave it alone and move on to the next issue to fix. My answer to that question is that doesn't gin up my base to come out and vote to make sure I get reelected. No, I will tell you, part of the voter ID debate, and actually part of the religious freedom law, was we want to make sure that we gin up our base to come out and vote. We want to give, you know, and both parties do this. When the Democrats were in charge, we did it, and the Republicans do it.
Okay, you know, the day you're born, okay, there's one time in your life we know you're you.
Yeah.
Okay, okay, you know,
That's called real ID. We don't do that. Sorry. We had. Oh my God! I forget you guys are back here. Hey, let me go to this guy real quick, then we'll come back to you. Yes, sir.
What, in your opinion, would be a fair voter ID?
Oh boy, that's a. I'm against.
What is it? What would be?
Here's the irony. Okay, I want big bad government off my back, but when it comes to voting, let's have big bad government get involved and make sure I got a big bad government approved ID to go vote.
Yeah, but what would you propose?
Well, I wouldn't do a government-issued ID. I think as long as you have a system in place to guarantee that you don't have voter fraud, so that Susie doesn't come in and say that she's Tommy, I'm being obnoxious, and vote on Tommy's behalf, as long as you have a system set up to make sure that doesn't happen, I'm fine with it. Pardon?
What system would that be then?
I kind of like the one we got now. Because I'm trying to find...
In the mail where my daughter can vote, and she's living in Utah, and then, but before that, she lived in Colorado, and she's been married.
So if she votes in Colorado and in Missouri, that's a problem. However, here's the deal. Here's the deal. If it's, you vote where your permanent residence is. What's your permanent resident? It's where you intend to stay. So I could be right now in Texas where I've got another house. And I could be there 363 days out of the year with the intent to permanently move back to Missouri, and I could consistently vote out of Missouri. Now, if I vote in Missouri and Texas, that's the problem. But it's subjective on where I want to ultimately stay and be, kind of. Yeah. Yes, sir.
So, the issue of voter ID, as I understand it, is to prevent fraud. Is that what it is, voter fraud? What is the extent of voter fraud? From what I've heard, it's minuscule, and the real reason is they just want to cut back the liberal voters that are, and use that as an excuse. And why are we spending these millions of dollars in the state trying to fix something that ain't broke?
I agree with you. I agree with you. And now there have been instances of voter fraud, but it's been more along the lines of, say, Tommy or Susie voting in Illinois and in Missouri. And that was the case from just, a year or two ago where somebody actually did that. But actual voter impersonation fraud that an ID would combat doesn't happen.
May I answer that?
Oh, I don't
Absence
care,
of
sure.
proof is not proof of absence.
Pardon?
Absence of proof is not proof of absence.
You know, that's what I think about the Penny Hubbard Bruce Franks case, where, oh my God, there's fraud, there's fraud, there's fraud, there's fraud. I'm going to file a case, there's fraud, there's fraud. How do you know there's fraud? Well, there is fraud. Can you show me evidence of a fraud? Yeah, there's fraud there. Look at all those absentee votes. There is 352 absentee votes. That's got to be fraud. Well, in the district next door, there were 351. Was that fraud? No, this was fraud. And again, the trial proved that there was no fraud, but it flushed other things out. So I'm having fun, but pardon me. The election authority did not follow state law, so I guess you could say that that was illegal. But then there's the debate of, again, if you as the voter go down and follow every single law that you're supposed to follow, and the screw up is on the election authority, not on you, is that grounds for an election to be thrown out? And we have Missouri precedent on that in essence says, if it's so outrageous to where folks lose faith in the system, then yeah, you can throw it out. And that was the judgment call that the judge made. Yes, sir. Hmm? I don't smoke. No, I'm kidding. Oh, I'm sorry. The question was about some of the other constitutional ballot proposals that are on the ballot Tuesday. But I don't want my comrades in arms over here to throw things at me if we segue.
Yeah, it feels a little off topic, but I would suggest that, there are some very good nonpartisan voter guides out there, like the League of Women Voters puts one out, and the paper does as well, where you can find more information about the other measures.
I am kind of going to default to Denise on this. Denise has come down to the General Assembly the past 8 years to testify on these issues and similar issues. And these are actually the questions that we asked that Denise answers. So I'm going to turn this over to Professor Lieberman.
But y'all can, you can come to it. We should all stay up here. No, and these are really good questions. This stuff is complicated, even for those of us that specialize in election law. So you have to be a United States citizen in order to register to vote. The way that that is attested to in Missouri is that you complete a voter registration card that you sign under penalty of perjury, and you must attest and check the box indicating that you are a United States citizen. If that is inaccurate, you can be convicted of voter fraud, and voter fraud is a very, very serious crime. You can be incarcerated for up to 5 years, up to a $10,000 fine, and you lose the right to vote for the rest of your life. So now, our neighboring state of Kansas has attempted to put legislation that would require people to provide documentary proof when they register to vote. But here in Missouri, you attest to it under penalty of perjury on the voter registration card.
This is sort of in the news, and I don't know if it's true. but the government said that they gave U.S. citizenship to 800 people who had been ordered deported, and they asked for citizenship under a false name, and they got it. So if I have 800 foreigners say that they're citizens, who's going to challenge that if there's no documentation or ID?
Well, there is documentation. I mean, there are federal immigration. So here's what we don't have. What we don't have in the United States is one database of United States citizens. Okay, so we don't have that. That does not exist. And there's a long history, a reason why it doesn't exist, because the colonists, when they came here, were fleeing a monarchy and a strong, I mean, that's why we have state-centered, that's the whole reason why we have state-based voting laws in 13,000 different election jurisdictions. But one thing we don't have any database, there's no list of all people who are citizens of the United States. But there is a list of people who are immigrants and going through the immigration process. And so there are various databases that other states have attempted to use, federal immigration databases that they attempt to match against voter registration rolls to try and identify people. Those have also been found to be faulty because there's a lag time between the time when people become United States citizens and the time that those databases get updated. But that's sort of the short answer to your question.
Do any other large recognized democracies like Australia, Canada, Great Britain have these sort of very myopic, very tussled over, fought hard things around voter ID and all of this sort of contentiousness? Is this an ongoing thing there, or are we being just a little too American?
No, they have to prove that they're citizens to vote.
Well, we do the same thing. We attest to it.
No, we don't. We attest to it. No, we don't. The answer was that you just go and sign a card saying that you're...
No, you attest under penalty of perjury. So here's the short answer, because I want to make sure that these folks can talk as well. Because we actually do a comparative piece in my class. I don't know if you do. It's really fascinating. But so it's different everywhere, you know. I mean, the laws are different in every country. But the one thing that does distinguish the United States is that elections are creatures of state and local law. In many other Western countries, elections are run at the national level. And so you don't have the same sort of disparities that you have in the United States. In the United States, we don't have any national ID. We don't have national regulation of elections, except in limited circumstances. It's all state-based. And so it creates a very different system.
Okay.
Yes, ma'am.
I kind of like your thoughts on two things I've heard on the news, which I'm sure at least one of them most of you have heard. One was a legislator, sorry I know, have to be more specific, in the East, who said we're so happy with the way they changed the voter laws for ID that he said now Republican candidate is a shoo-in, there will be no problem. The second comment I heard, actually, it was Brian Williams said it was well before he left NBC. He said that if we don't change the laws, that the gerrymandering will make every state Republican. Those are the two comments I wonder if your thoughts about.
We have a gallery member here.
So it's been said that the polarization of Congress and maybe even the Missouri legislature is because of gerrymandering, and that districts have become solidly left or solidly right, and there is no need to find a middle ground for a representative who would represent that district, because there's left and there's right. And back in the days of smoke-filled rooms, there was that kind of discussion, and a representative had to come back to his district and appeal to both sides, and as a result, you got somebody who was more moderate. Now, are we ever going to see that again?
I don't know, because I'll tell you this much.
follow up on my own.
We,
Along with the TV report, they showed an example of several states, and one of them, there was a circle totally surrounded by a different district, and this isn't my idea of redistricting.
well, no, here's what's frustrating. I let it slip. I have another house in Houston, Texas. You know, Texas, you think Republican, 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 Republican. However, you know, the city of Houston had a lesbian mayor for 8 years. Dallas, their sheriff is a lesbian. They're all Democrats. Houston's all Democrats. Austin's all Democrats. San Antonio's all Democrats. But Austin has one Democrat representative and what, 6 or 7 Republican U.S. congressmen? Because they draw the lines like the spoke on a wheel to make sure that they can, and that was Tom DeLay, you know, to make sure that they had as many Republican reps as possible. I think the two issues dovetail from the standpoint of, yeah, you're right, that because of this gerrymandering and things like the Red State Project, a very quiet project that the Republican Party put into play about a decade or more ago to make sure that local state house and Senate races were funded properly to give Republicans majorities for the sole purpose of redistricting in 2010, 2012. Because of those issues, you're seeing more and more polarization and more Republican representation. Now, I would toss it out there that if the Democrats were in charge, they would try and do that. We would try and do the same thing. It's the nature of the beast, kind of. States like Iowa are doing something a little bit differently. I mean, they have a nonpartisan redistricting program that will toss incumbents in the same district, and they don't even bat an eye and care. That's something that they voted on, that they wanted to switch to. In Missouri, the Bar Association put together a committee after the redistricting this last time around to see if there was a better way to draw our congressional, state house, and state senate districts. And after a couple months of meetings, myself and Senator Eric Schmidt was on that committee. We decided Missouri's system may not be the best, but it has equal opportunity for both sides to come in, swing the bat, and get their maps approved at many different levels. First at the state house level, then there's a commission, then it can go to the state house, then it can go to the commission again, then it can go to the courts. We thought that there were enough checks and balances in there to not have a too horrifically gerrymandered state map. But kind of one of those things, you know, 8 years after, it's like, wait a minute, no, actually that was kind of bad because it obviously didn't work. But now here's the beauty of it all, you know, because career politicians are bad, institutional knowledge is bad. Everybody that learned that lesson in 2010, 2012 with redistricting, we're all termed out. Now the new kids have come on the block, and the real power, the professional lobbyist class, who have become the institutional knowledge, who their main game is, I don't like change. You're in power? Sweet. Let's keep you in power because I don't like change. I like predictability. It happens to be the Republicans. You know, I say should we change it? I think so. Will we? I don't know. I mean, you know, Congressman Carnahan was not successful in his lawsuit. And there were some pretty gerrymandered Missouri districts. But again, what makes me even more grumpy is it was blatant. Blatant. We want to write Russ Carnahan out of our congressional districts. I wouldn't do that to Ann Wagner. No, really, hey, you got to admit, Ann Wagner's more of a moderate Republican nowadays. But here's the beauty of Ann Wagner. Ann Wagner does work across the aisle very quietly. Of course, I would still vote for her Democratic opponent, but she's part of that old school that understands on certain issues, policy is more important than our political party platform.
Okay,
And I'm sorry, that was a long answer.
Take a final question.
Yes, ma'am.
Back in the late 60s and early 70s in Arizona, we knew a lot of people that were what we would call residents of the state. They'd come from Canada or other countries to work in Arizona. They were not allowed to vote in federal elections, but they could vote in the state and the local ones. Does Missouri still...
Missouri does, No, Missouri doesn't have that, but some places do. It's actually really interesting, actually. There are several, federal law says you have to be a United States citizen to vote in any federal election, but there are some local municipalities that allow non-citizens to vote in local elections. So there's some boroughs in New York, for example, that have high immigrant populations that have lots of children in the schools, and they allow those folks to vote in school board elections, but they're not allowed to vote in federal elections.
Arizona's rationale was they're paying taxes, they're paying into the tax program,
Yeah.
and paying all these other city, state taxes. Let them have a voice too in what's happening in the state of the city.
You know, there's so many questions about voting and who gets to vote and how and why that you know, I think we could be here all day. But I hope that this is sort of giving you food for thought to think about how you think about voting. I mean, some of it's politics, but it's bigger than politics. Because how we think about voting, sort of even your question now, sort of gets to sort of who gets to have a say, who gets to be part of the process, and that's a bigger philosophical question that I think is a really fascinating one to ponder as we head into Election Day in a space that's so partisan, so nasty, so full of vitriol. Maybe we should step back and think back, what is the right to vote sort of really about? You know, and it's the only institution in society where truly everybody weighs exactly the same. And I can't think of another one where, regardless of whether you are a pauper or rich, your weight is exactly the same. Regardless of whether you have a high school education or a PhD, your weight is the same. And that's very interesting. And that's part of what makes the right to vote so controversial. And that's precisely part of the reason that we debate so heavily who should have the right to participate in and on what grounds.
Well, and actually, just to wrap up, I want to thank you guys for being here. One thing that I've kind of learned over the years is to trust the voters. And I think it's actually part of my job as an elected official to not just trust you, but to make sure that you have the information that you need to make the right choice. Now, a lot of times that information is information I don't agree with, but that's where it comes back to trusting you to make the right decision. I mean, you need to hear these arguments on why voter ID is necessary and how maybe the new law, if it goes into effect, won't hurt anybody. But then you also need to hear the arguments on why some folks think it will. But at the end of the day, I do have faith in our system. I have faith in you as the electorate to do the right thing. So, and that's exhibited by you being here tonight. So thank you for being here.